are in April, which is 5 months after my original complaint was filed in this case. And on November 5th, before I even filed the case, the governor's office asked a public records request of the legislature of this exact same set of information. And the response I got when I went to the public records officer was, I said, I want those same documents that you asked for back on November 5th. And she responded, the records you are seeking are documents that were produced by the legislature to the governor's office. But they said the records in our possession are privileged and they cannot be produced. I said, I want them even if some of them are redacted, which I don't understand why a public document would ever have to be redacted. And nonetheless, I was denied from doing it. They already have the documents that they're talking about. If they had something, the smoking gun, they could show it to us now. The idea of delaying this thing any further, I believe, does not serve anybody better. I think the April 15th date, again, 5 months after the original complaint was filed, is plenty of time for them to be able to go fishing around to find something that they think is going to justify what he did, which is looking at the bill, getting rid of a subsection, getting rid of individual words, getting rid of individual sentences. But my major point that I would also just re-emphasize, other than me already granting them 5 months continuance already, is the governor was in on the delay provision. In my amended complaint, I pointed out, quote, Governor Inslee, in order to pass the bill, struck a deal with legislators to include a delay in the legislation. But when the bill arrived on his desk, he broke his end of the bargain and vetoed that subsection. It cannot be that they manipulated the situation when he was in on it. If he's part of the process that's going forward, the idea that somehow they move things around with him without being aware of it, it's almost like he's accusing them of what he's guilty of. So again, we're kind of back to the enroll bill doctrine, which is the bill is what the bill is. It's right before you right now. You're able to, and I've done everything I could to have this expeditiously decided. They have from now until April 15th to review all the documents, which they already have, to be able to find this smoking gun information. But as I reiterate, Governor Inslee was negotiating with them, and he agreed to include the delay in the legislation itself. And so therefore, the idea that somehow they did something behind his back, if anything, he seemed to pull the rug out from underneath them. He negotiates a deal, puts a delay in it, and then strikes it out. The problem we're having is it's now nearly a year later, and two policies that the legislature said they didn't want to have take effect immediately took effect immediately a year ago. And justice delayed is justice denied. This should have been decided a long time ago. The only reason it's now before the court at all is because of your ruling, because the Supreme Court upheld your ruling, and 3 days later I filed a complaint because nobody else was filing any complaints about it. It is a maddening process that this has taken this long already. I believe April 15th is a reasonable amount of time for both parties to be able to prepare, and I believe the case is self-evident that he's not allowed to veto individual words, individual sentences, subsections. It's all before the court already. The smoking gun emails, which are privileged and cannot be produced to me, doesn't make any sense because, again, these are all public documents. So I'm angry and frustrated that I asked for the exact same materials that they asked for on November 5th, and they've already got them. So I would respectfully request that the court deny the partial continuance because, as you pointed out, they can't even figure out when they think they might get what they think might have something in it, and it should be both together, because there were two bills originally brought forward in the complaint, and both of them he did the same thing that he was found guilty of, or found that he exceeded his authority by the Supreme Court. I think Inslee 1 is operative, and that there's no huge difference. Final point, this is brought under a CR 56D summary judgment motion, so it's really up to the court to decide what kind of substantial controversy there is. And so far they're basically saying, give us more time so that we can maybe find some. Even if you think they may have something, they would already have it, and they could show it to you in camera if they had to, if they think that there's something relevant to it. So I appreciate your consideration. I have done the best I could to move as quickly as possible, because I want this resolved as quickly as possible, yet I've given them 5 months to be able to prepare. I think that's more than enough for a very straightforward case, which I believe Your Honor is very capable of being able to examine. Look at the bills, words, sentences, subsections being vetoed. You can't do that. That's what he did before, and I would ask you to deny their request for more time.
Thank you.